Lisa Manheim is the Charles I. Stone Professor of Law at the University of Washington School of Law. She writes in the areas of constitutional law, election law, and presidential powers. Much of her recent work examines institutionalism and federalism in American election law. She also serves, as we'll hear more about, as co-reporter on the restatement of the law election litigation, a project of the American Law Institute. She's appeared on air and in print in a range of national and international outlets. She's been recipient of multiple teaching awards with courses that include administrative law, common law, election law, federal courts, and legislation. I saw one of your former students stop by to check in on where at-law is today, which is a topic for a different day. Professor Derek Muller is a professor of law at the University of Notre Dame Law School and is a nationally recognized scholar in the field of election law. His research focuses on the role of states in the administration of federal elections, the constitutional contours of voting rights and election administration, the limits of judicial power in the domain of elections, and the Electoral College. He's published extensively, including op-eds in the New York Times, the LA Times, the Wall Street Journal. He's testified before Congress, among other things, in support of the Electoral Count Reform Act, which was enacted in 2022, and which I'm going to want to talk to you both about a little bit. And he's co-author on a federal courts casebook at Notre Dame. He teaches election law, federal court civil procedure, and evidence. So welcome to you both. Thank you for making the trip here. Let me say that I first got to know Derek when he was a law student and was, I think, the first law student to submit an article to the peer-reviewed publication Election Law Journal that I was co-editing at the time with Dan Lowenstein, and we accepted that article and set a trend of accepting some student articles. Hard to get into a peer-reviewed journal when you're a law student. He was writing about the Electoral College, and he's I think well-established, one of the foremost authorities on that issue today. So it's really nice to come full circle. I was having a breakfast with Dan Lowenstein, who was my election law teacher here in 1990. I took it as a student with Professor Wallach. We were in the same room and we were disagreeing even then, civilly, which is part of the theme today. And I was telling him that there's going to be this new project. He was very excited to hear about this project, very excited to hear about the reporters on this project. And he said, well, of course, in election litigation, the parties are going to just go at loggerheads. There's nothing more political than election litigation, Democrats versus Republicans, candidate versus candidate. And so I want to start with this question. I'll start with you, Lisa, and then ask for Derek to weigh in. We often talk about the voting wars. I had a book called The Voting Wars. I don't take credit for the title. The title actually goes to Professor Judson Levitt, who was a visiting professor here. It's a professor down the road at Loyola Law School, came up with that title. War is a very strong word to use. And what do you think, personally, what do you think the term means today? Are we overusing, are we over dramatizing the fights between the parties? What does this mean that in courts and legislatures and the public we're talking about this? Even today, New York Times headline, latest skirmish in the voting war on mail-in ballot.
Thank you, and thank you so much for everyone for coming today and for the invitation to join you in this discussion. Often when we use the term voting wars, we're referring not to necessarily candidates who are trying to battle over specific votes, but instead we're talking about fights over the rules of elections, with the idea that if the rules of elections are changed in one way or another, that can, particularly in a close election, tip the result in one direction or the other. And we've had these fights for hundreds of years in the United States, and it is, in a sense, just part of the electoral process. What I would say has changed in recent years, and certainly in the last couple decades, it has changed in ways that make that term war, and then, of course, the term war is a rhetorical term. It's as you suggest, it's exaggerated in a way that actually may itself ironically be problematic. But what's changed in the last couple decades, I would say, is at least three things. So first, these fights over election rules, they are very well funded and organized now in a way that they weren't, 20 plus years ago. Number one. Number two, a lot of these fights are occurring in the courts, whereas earlier in American history, there was not the same sense that the courts should be involved in resolving a lot of these disputes. The courts were resolving these disputes, but not to the degree that we're seeing today. And then the third big change is, I think the most troubling, which is that what we're seeing in recent times are actors that are trying to change these rules sometimes in ways that are inconsistent with the rule of law. So they're trying to, in a sense, subvert the rule of law in an effort to change the rules, which will then, hopefully change the outcome in their favor. For what it's worth, I would say all three of these changes help to underscore just how important lawyers are, how important law-trained members of the electorate are, because these are things that can be really difficult for people to understand. And what all of you are doing as law students is getting educated in the sorts of principles and ideas that then help to inform our understanding of the so-called voting rules.
Thanks, Derek. You are like me, very nerdy and liking to count things. You probably like to count things even more than I do. One of the things we both count is election litigation. I count the number of cases from a sample, and you count the amount of money, which maybe tells a little about what's happening with the money. But is there a sense that the voting wars are expanding? Are they changing? What is behind all this?
Yeah, I mean, these issues can be quite cyclical, right? So maybe in the 80s and 90s, things could have been quite quiet in some respects, although to use another war term. In 1984, there was a congressional election out of Indiana known as the Bloody Eighth, because of the battle of that one congressional seat. You can go back, obviously, kind of voter intimidation and outright hostility and violence that was happening in the late 19th century in terms of Reconstruction after the Civil War. So there are these moments in time where I think about these issues, being pitched. In the 1960s, the Supreme Court was very active in redistricting cases, one person, one vote, and thinking about voter eligibility, where it had a lot of litigation that was happening. So it's not like it was a new thing. But I definitely since 2000, and I think we can pinpoint that, and not just because that's where Rick pinpoints some of his counting, thinking about election cases, but as a place where we have a very closely divided country and recognizing that pitched battle over the rules of elections, where a few hundred votes are at stake that can turn a presidential election, mean that there's now fights everywhere because everything might be at stake. And in the last 10 or 15 years, we've seen a dramatic uptick in the money being spent on litigation in these election law cases. It used to be that you would look at the campaigns, they would spend about $3 to $5 million, the major parties, major presidential candidates, in litigating these issues, just hiring up lawyers to do things. So part of that's a little artificial because prior to 2008, the campaigns opted into public financing. They only had so much money they could spend as a presidential candidate, but obviously the committees could spend a lot of money, but they spent that on advertising. They didn't spend as much on lawyers. That $5 million figure a year has now, is somewhere between $50 and $100 million a year on legal expenses alone. It's a lot of lawyers and a lot of retainer trying to figure out.
Sounds good for our students.
That's right. Great for the students now. Great for that practice, right? And you can look at a lot of the litigation that's being filed, and sometimes you wonder, you might open the newspaper and read about a lawsuit being filed and say, like, how much does this really affect things? What's the likelihood of success on this? And in some respects, I think it's a sad thing to say, I don't know how much of a likelihood of success there is, and I'm not sure that's the point. Increasingly, as you spend more and more money on litigation, just thinking from a law and economics perspective, you are increasingly spending it on more and more marginal litigation. You have limited resources, you're going to focus on the biggest cases. And the more money you spend, the more you're focusing on marginal litigation. Or sometimes you will have 6 or 8 lawsuits filed by different groups on the same thing because they all have money to spend on litigation and they're all spending it. And so sometimes, in Georgia, you can see fights over SB 202 and literally 100 lawyers will be on the brief representing several different organizations because there are a lot of people involved that want to have a lot of say. So these things are important, and so we're passionate about them. We want the rule of law to prevail, but we're definitely in a place where we have pitched battle in the litigation front, and we have more money than ever and more lawyers than ever, investing more resources than ever in fighting about these things. So it puts a tremendous strain on the judiciary to resolve these disputes efficiently, and for the judiciary to resolve them in a way that doesn't appear partisan, especially when maybe before the election, but especially after the election. There's going to be a winner and a loser that comes out of this case. It has a significant partisan valence where Democrats support one thing, Republicans support another thing. So that puts the courts in a very precarious position as we're thinking about the litigation. We think about it being pro-voter, pro-rule of law, anti-fraud, whatever you want to say. But there's that heightened partisan valence at the end. And that's, I think, what makes the sort of voting wars terminology, especially with litigation, all the more all the more challenging.
Let me stick with you, Derek, and ask about what it sounds like you both agree that there's maybe too much litigation, maybe too much bad litigation, maybe push back if that's not true. Is there something that courts or we as members of the bar, is there something that we should be doing about it or some way of thinking about it that could lessen the voting wars? Or are the voting wars just inevitable when you have a kind of closely divided, highly polarized electorate that what basically the litigation just reflects the divisions in society over who we think should be in office?
I mean, it seems a lot like the latter, right? It seems a lot like there are these, if we're closely divided and every vote matters and we're fighting over which Senate seat is going to give you to 50 or 51, or which House seat is going to get you to 217 or 218. I mean, these are the margins that we're facing in Congress right now. And then when we're thinking about electoral votes, similarly close margins. This isn't Reagan 84, this isn't Nixon 72. These are places where we have such fights over such marginal, marginal margins of victory, where we have a lot of challenges arise. So, you know, I've been an advocate, and a lot of people don't like it. I've been an advocate of calling for less litigation, just less litigation across the board. And there are ways of doing that. So there are ways of modifying some of the campaign finance rules that were changed about a decade ago that allow people to earmark money for litigation. So you can give only, I use that term only in scare quotes because there's law students in the room, only $3,300. Only $3,300 to a presidential campaign. You give only $3,300 to Kamala Harris or to Donald Trump's campaign. You give about $110,000 to their lawyers. There's a significant mismatch in the money allocation of the current campaign finance scheme. And so when people get nervous when they think about the fact that, you know, they say we should have less litigation because more should be left to the process, to voters, sort of the ordinary way that we typically handle these disputes. People get nervous. They, well, I want less litigation, but I want less of the other side's litigation. And I want to preserve where my side's litigation is, because I think my side's really important. But I think we're thinking about less litigation overall. Again, we're thinking about channeling those resources toward the most important or most impactful litigation and reducing the more marginal things. So we can think about creatively at the back end about should there be more places to sanction lawyers? We've seen a lot of that after the 2020 election. The question is whether it's having the deterrent effect we might think about. There are obviously bar proceedings for different litigants. It might dissuade them in certain respects about factual allegations. I think there's an interesting question about the legal allegations. But there's tremendous strain in the system because you can't just pass laws saying less litigation. Right? We have statutes that are important. You know, the Voting Rights Act, Motor Voter, Help America Vote Act that we want to litigate. We want to be able to preserve these rights. We have constitutional provisions relating to the right to vote, and we don't think we should just dilute or diminish or ignore. So we're just in a situation where we just have these escalating costs, but sort of no de-escalation mechanisms.
Liz, do you agree that maybe we need to lessen litigation? If so, how might that happen?
Well, so these sort of a big kind of overarching question like that is going to be hard in a sense to answer, because on one level it depends on the litigation we're talking about. So if we're talking about frivolous litigation, nuisance litigation, that's problematic. At the same time, courts do have ways of dealing with that type of litigation. One way I think of thinking about the way we structure elections in the United States is the following. In a lot of other countries, what they do is they have nonpartisan officials who design election rules and run elections, and then they do not have the courts playing that prominent role. At least they don't have the courts playing the same role that we have been playing in the United States. By contrast, in the United States, a lot of the rules of elections and the way that they're administered this is all conducted by partisan actors. And so if the partisan actors are sort of unchecked, we worry about what the elections are going to look like as a result. So what we've had developed over time in the United States is this sort of the judiciary as a backstop on sort of pushing back when the sort of partisan actors have overstepped in some ways. So with all of that in mind, what I would say is that there's a real value that's being served by the court's involvement here. And the question then is, there's a few different questions. One is institutionally, what are the courts able to do? And what are they not able to do? What are they good at? What do they really struggle with? And how can we then sort of adjust the rules of litigation in ways that makes it easier for the courts and sort of gives the litigants the right incentives to bring the right types of cases rather than sort of flooding the courts with litigation that really shouldn't be there.
I meant to say that I will leave time for you all in the audience in person if you have questions. We don't have the capacity to take the online questions today, but we will be able to take some questions for in person. I want to talk before we get to the restatement project you're both working on about timing issues and how courts approach issues before and after the election. And so I don't know if any of you are following the fights, particularly in Pennsylvania right now. Pennsylvania, battleground state, lots of fighting over the rules for mail-in ballots. And there was a lawsuit that was brought, I guess a few months ago. Pennsylvania apparently has this special court that deals like a trial court level that deals with constitutional issues. That's kind of neat. I don't know if there are any other states that have that. Someone brought a lawsuit and said that people who fill in mail-in ballot and they're timely, they've arrived by election day, but they put the wrong date or they fail to put a date, under the state statute, those ballots aren't counted. So a while back, there was a federal lawsuit arguing that this violates a part of the Civil Rights Act. So far, that has not been successful. There's actually a petition for cert before the US Supreme Court that will be considered after the election. But there was a state lawsuit that was brought, and it was brought in this Commonwealth court, and the state court said that this provision violated the state constitutional protections for the right to vote. There's protections for the right to vote in the US Constitution, and there's protections in state constitutions. Those protections might be broader than the protections that we see in the federal constitution. And so the lower court, this Commonwealth court, said this is a violation, those ballots have to be counted. And we think there could be thousands of these ballots, and it's possible that it could be that could determine the entire presidential election, whether or not these ballots should be counted. Case went to the state Supreme Court on a technicality, tossed the suit, said you didn't sue all 67 counties, tough luck. So then the ACLU just a few weeks ago filed a lawsuit directly in the Supreme Court of the state of Pennsylvania. So I call it King's Bench Authority, for those of you who are fans of the law of equity. You know, this is basically like the chancellor should use the chancellor's discretion to decide whether to take a case. And just this past Saturday, the state Supreme Court said, too late, we're not going to get involved just before this election and start changing the rules. And I was concerned if they took the case and they said there was this right, there would then be a federal issue about whether the state court was changing too much in the state legislative rules. This is a big windup to ask Lisa first and then Derek. Here you've got a situation where you've got these voters that are going to be disenfranchised for an immaterial mistake. And yet, there's a real value to finality, to not trying to change the rules just before the election. I should say that the court, the Pennsylvania Supreme Court also threw out a Republican lawsuit that was seeking to prevent voters being notified that they had problems with their ballots to cure them in time. The court also said the timing was off on that. Like, how do we balance these concerns about that? Now we're getting more into the substance than into the kind of the generic question of the voting. How do you balance this fact that there are going to be thousands of voters who are eligible to vote, whose votes are timely, whose votes are not going to be counted for this non-technical reason, with this idea that it's really problematic to be changing the rules just before?
Okay, so there's a lot to say here. And I'm actually going to start by answering your question a little bit indirectly, and then I'll try to answer more directly. So in this sort of saga out of Pennsylvania, let me tell you about two other actors who are involved in this. The first is the state legislature. And what the state legislature had, among other things, was its own bipartisan advisory board a while ago now, going back through identifying this issue. And again, the issue is there's ballot, that's fine, other than that the voter just didn't date it. Should that be counted? The bipartisan advisory board recommended to the legislature, you should pass a law clarifying that this ballot should be counted, must be counted. The legislature failed to have it. So we're already in a second best world. That would have been the best resolution with this, in my view. The legislature actually acts in response to this recommendation, clarifies this as a matter of statutory law. Okay, so that's one actor. Let me tell you about another actor. And those are the election administrators in Pennsylvania. And what have they done in response to this controversy? Ready? They redesigned the ballot to make it really, really clear that you should date it. So their answer to this was not to sort of engage in what you might think of as sort of the voting wars, there's a winner, there's a loser. Instead, they said, okay, well, it looks like this requirement may be one that is going to be a problem. And so we are going to try to help the voter, not by necessarily circumventing this rule, which we can't do if the courts don't allow us, but instead to adjust what we're doing to help the voter grapple with this rule. Okay, so there's, I would say, one actor really not doing what the actor should be doing. On the one hand, another actor handling this in a terrific way. When it comes to the courts, and specifically the Pennsylvania Supreme Court in this case, I actually may defer to Derek on that. I'll say one thing, but the reason why is because we talked about this on the way over, so I know you have thoughts about it. What I would say is that the courts didn't necessarily have to be put in this position, not only because the state legislature could have acted, but also because the litigants in question could have brought their lawsuit earlier. And so I think if you look at this case in isolation, I find it very frustrating that the Supreme Court didn't answer the question on the merits.
The state Supreme Court.
So the state Supreme Court, yes, thank you. I find it frustrating because we need clarity on this rule ahead of time. That being said, if the state Supreme Court is willing to sort of respond to litigants, even when the litigants haven't named the right parties, even when the litigants haven't brought the lawsuit as early as they should, then what effect does that have going forward? It gives people an incentive to do those sorts of things. So just like with everything else in this area, it's complicated. But Derek,
Yes. Sure.
Yeah.
I know we've talked about this.
Yeah, well, I'll only briefly push back on something Rick you said about the word immaterial there. When we're looking at the absentee ballot envelope, you can think about the date, as you sign it and date it. And I think there's at least one aspect I think we could argue is immaterial, and that would be the year, because everyone knows it's 2024 when you're mailing in this ballot. You're not mailing a ballot from 2020 or a ballot from 2028, right? And one of the things that the state of Pennsylvania did, and some of these counties are doing, is they're printing the date, the year on the envelope so that you can't mess it up because that 1 year is on the envelope. Now, the downside of this is it's more expensive to print more stuff. You can't reuse the envelopes, so you have to burn them when you get to 2025. So there are costs to that. Okay. Very good. Yes, we're in California. We recycle them. Compost them. But then you think about the date, right? So when you date that envelope and you say it's October 1st or October 8th or October 15th, you're attesting, you are a resident, you are not convicted of a felony, you are an inhabitant in this point in day and time. So there is information about saying, like, at this point in time, I am eligible to cast a ballot. And even if I get arrested later or there's some problem that happens, we can find out that at this point in time you were eligible. And there are problems about thinking about the counting of ballots. There may be anything that's not sufficiently important, right? You could say that's not important, it's not really used. Who goes and investigates those things? That's I think what the core of this dispute is really about. How material, how important is it in the first place? Is it just not important at all? I think the date the year probably reaches that level, or is it just relatively unimportant like the rest of the dating information? But I completely agree with Lisa thinking about the legislature's failure here, and the legislature and executive that are just at loggerheads, unable to come to a consensus solution. But the litigation here is frustrating. This is not a new problem in Pennsylvania. I mean, we've been writing about this for 4 years. I mean, going back to 2020, it's just the same stuff over and over again with litigants trying different strategies in the vacuum created by the legislature. And as the litigants are going, this most recent version, we talk about it as a technicality, but Democrats sued, and they sued challenging 2 of Pennsylvania's counties. Philadelphia and Allegheny, where Pittsburgh is. They sued just 2 of them, leaving the other 65 parties off to the side. And that's a challenge, because if you think this is like a fundamental right to vote issue, you would think all 67 counties should be instructed to do the same thing, especially in a state that has very strong home rule, as we call it, which is the counties have a lot of flexibility and discretion, and a reason why you have to go and sue all of them. Like Republicans tried this in 2020. They tried suing some counties like Fulton in Georgia, and the cases were thrown out because they got to sue all of the counties. You can't just pick and choose which of the counties you want. This is a fundamental right to vote issue. It's something that's going to affect the voters of the statewide. But again, I think about the litigation posture of the case. It was, again, I think there's some strategic decisions happening to sue just 2 counties. and sue them very late. We've had years and years to look at these problems, and then to sue again in sort of extraordinary King's Bench jurisdiction at the 11th hour. So we can sort of say that there are situations where maybe I'm more sympathetic to say these are new statutes or new regulations. What's happening right now in Georgia, where there are changes that the state election board is making weeks before the election, you don't have any time to sue until those things are put in place in September, entirely understandable. It becomes more of a challenge to think about litigants who are on notice about these issues and are suing very late in the day. And it places courts in a very difficult position, because the inevitable thing in the nightmare scenario, right, is that now we come up after the election. And there are now batches of ballots sitting in these county offices that are not being counted because of the lack of a date. And maybe we know there's 10,000 of them, and the margin of Pennsylvania is 5,000. And now all of the pitched stakes are, what do we do after the election with this stuff? Maybe we couldn't resolve it before the election, but now some voters are saying, no, please count my ballot. And that puts courts in an even more difficult position. So in some ways they want to just stay hands off and say, let's hope the margin of victory is wide enough that there's not going to be litigation. But in other ways, it can create additional pressure after the election if it turns out to be particularly close.
So you think that there's still the potential for this issue to be litigated post-election, that, like some kind of, you're a Civ Pro person, I don't know what we call this, a non-mutual offensive collateral estoppel or something like that?
Yeah, I mean, if you're a voter whose ballot is missing a date and it's sitting back there, in a storehouse in Philadelphia, I imagine if the margin is close, the litigants are going to show up and sue. And whatever other litigants were suing before the election is going to be a different universe than those who are suing after the election. And we've seen this in the Franken-Coleman election in 2008. You see this in places where it's very close and people are fighting over the last tranches of ballots that were counted, weren't counted, whatever it might look like. But it's pitched battle, to use the war metaphor again, pitched battle when the margin's very close.
So if you had a non-mutual offensive collateral estoppel on your bingo card, you're a winner. I didn't expect to use that term today. This is like, the reason I asked about this in part is because, this choice between voting rights and finality, these are things that get balanced, access versus integrity, fraud versus suppression. This is kind of the partisan frames, at least by which there's public talk about this. There's public talk about the voting wars, and you are both involved in a project that is meant to bridge that gap. And you come at this trying to bring together a diverse group of people to agree on a set of rules. So maybe I'll start with you, Lisa. Can you tell us about this project, this restatement project? What is the American Law Institute? What are you trying to do? And what are you hoping to tackle? What's the end going to look like, 5 years from now, whenever it is that the project is done? And you should be lucky if your restatement project is done in 5 years.
Yeah.
Mine's going to take about 8. Go ahead.
Have you all encountered restatements as law students? Okay, so.
Too much.
Well, that's the thing, you all presumably consult them and your professors assign them to you because they are helpful. Now, what are they? So the restatement is a publication written by a private entity. So, I could, each of you could in theory publish a restatement. It would be a restatement by you. This is a restatement that's published by, these are restatements that are published by the American Law Institute. And the American Law Institute is an organization that has, through time, garnered a lot of influence and been able to sort of produce resources that judges and others have found to be helpful, and therefore they've relied on them. There is no other legal significance of a restatement. So restatement, in other words, is only as helpful and influential as people who have power decided it. Okay, including judges. So with all of that in mind, the American Law Institute recently decided that it would be appropriate to have a new restatement, and it would be a restatement on election litigation. The goals of this project, there's many different goals of this project. I feel like two of the most important goals are the following. The first is to provide this sort of resource that we see in other areas of the law, right? So you have a property case, you go to the property restatement. Is it controlling? Are you bound by it? No, but you know what? It is very helpful. These judges who are engaged in this election litigation Often it's on an extremely short timeline, it's very high profile, and the stakes can be extraordinarily high. And so particularly in that context, as you can imagine, a number of you may do things like clerk, right, after you graduate. You'll be asked by your judge, figure out what the answer to this question is. It is really helpful to have a resource like this on hand. So that's one of the main goals of the restatement. The second main goal in my mind of the restatement is the following. To answer the question, is it possible to have a restatement of election litigation? Isn't it just a free-for-all where partisans are battling and it's war and there's no rules? And the answer, Derek and I feel resoundingly, is that is not correct. Election law is the law of politics, but it's still law. And so one of the main central goals of this restatement is to produce an authoritative, reliable, helpful text that, among other things, helps to demonstrate that it is not a free-for-all if you're going to challenge an election. You can't just file a bunch of lawsuits, throw things at the wall, hope you get a good judge. That's not how it works. There are legal principles that govern, and one of the goals of the restatement, again, is to basically make that statement. This is election law.
Yeah, I'll add just a couple of things to that. So one is, so when I was at 1L and I saw the word restatement thrown around, I kind of thought it was like a statute or statute-like or something like that. And then you realize, oh, it's just a private organization. It's an independent private organization that just does a really good job of trying to synthesize the law and trying to provide that clarity and modernization so that courts can be influenced. So whether it's the law of torts, the law of contracts, whatever it might be, those restatements, to varying degrees of influence, have had a significant impact in the courts. So it's also a little humbling to be brought in, 100 years after the ALI's formed and thinking about torts and contracts, saying, great, you are the reporters on the restatement, and we're sitting down, starting from scratch. It's not like this is the second restatement or third restatement. This is the first one to be developing these principles of election litigation. So as we enter this project, one of the even things that we've spent a lot of time thinking about at the outset is, what is the scope of this project going to be, right? How big, how small should it be? The bigger and more ambitious it is, the more exciting it can be, but also the more controversial it can be, the more it might be rejected by people. The smaller it is, then you sort of ask, is the game worth the candle here? What are we doing at the end of the day? So we're trying to find a way of hitting an appropriately sized project that has enough buy-in from the judges, the academics, the practitioners, who can agree that this is the body of what the law of election litigation looks like. These are the principles, these are the provisions, these are the concerns that we have, these are the constraints. And so that when these judges are put into very difficult situations, they have this off the rack set of rules that they can go to, that they realize have been carefully vetted. When I will occasionally speak to judicial associations, I've done this year, Indiana and Iowa's judicial bar, to talk about what litigation looks like for election law cases. And these judges are generalists, right? They typically don't see election litigation, certainly not an emergency posture after the election. And you can think about Florida 2000 and the judges that were suddenly thrust into a very uncomfortable position that they didn't anticipate they would be in, 3 weeks before the election. So we want to be able to provide some of those resources as best as we can, precisely to bring some of that clarity and certainty and modernization that the ALI strives to do in its restatements.
And I should just add, having worked on a restatement for a while in the torts area, that one of the things that gives the restatement some legitimacy is that the body of people who sit are quite diverse in every way you can think of. You've got plaintiffs in the torts area, plaintiffs lawyers and defense lawyers and judges appointed and elected from different parties. It brings together academics from across the political spectrum, and so it's not easy to get through you'll see soon, it's not easy to get through the gauntlet, the many different stages of approval. It's not just what you two think, it'll be what gets the approval, and there's a lot of give and take and a lot of discussion about what the rules should be, and so that helps to give it a little bit of legitimacy. And one of the things that I like about the process is that even though you have people in the room who strongly disagree with each other, and this comes back to the theme that Dean Waterstone was pointing out earlier, people don't have to agree, but they can still be civil, and sometimes you can reach compromise. And so this is the last question before I turn to see if audience members have questions. I want to ask more directly about this question of civility. how do you think judges, and let me start with you, Derek, how do you think judges, law professors, lawyers, law students who want to advocate for justice in elections, however justice might be defined, access, integrity, whatever you want to call it, how do you balance that with the importance of civility? And when these things conflict, how should these conflicts be resolved?
Yeah, I mean, I think, when we talk about civility, right, I mean, the key is in litigation in particular, and especially in short fuse litigation like election litigation, you have to be mutually working with the opposing party through the course of litigation to ensure things move expeditiously. That's very hard in pitched battle where it's a Republican versus a Democrat or whatever it might be. But the only way the litigation moves through the courts efficiently and expeditiously is when the parties are able to agree on kind of the minor procedural kinds of things about extensions of time, about the timing, about getting things in, about mutually agreeable discovery, about where the deposition locations are going to happen, all of the kind of mundane stuff of litigation that needs to happen in that kind of civil exchange, and recognizing that at the end of the day, you really want to win for your client, but there's a way of getting there that is not foot dragging, filing motions to compel, blocking access to things, whatever it might be. Now, at times there's going to be even intense disputes about what to disclose or what has to be shown to the other side. I think we saw in 2020 even litigation about whether or not observers could see what was happening in Philadelphia or Detroit when it came to the counting of ballots. And so you have those intense disputes. But I think at one level, if we're thinking about all litigation, there is sort of this level of civility that we expect in the legal profession. And especially if you're in election litigation, you're going to see the same people over and over. They're going to be repeat players. And hopefully in the 4 years before the election, you've been in sort of the less time sensitive places to be able to address them in a civil manner in the more time sensitive places in the few weeks after the election. So I think about that one level. The other is, I think, especially with factual representations to the court, there is this obligation that we have, this ethical obligation as attorneys to make non-frivolous allegations regarding facts and allegations of facts that are grounded in law. With law, sometimes there's some challenges about arguing for extensions of law or new law, and certainly in a lot of hot button election litigation, you have new legal theories being promulgated. But when it comes to the facts, part of this is you're in the fog of war, which is, using the war metaphor, you don't know what's happening in the 24 hours after the election, 48 hours after the election, and whether that's Florida 2000 or Pennsylvania 2020, there's a lot of uncertainty. But as you see the certainty arise, as you see more and more facts come into view, there is this obligation to clarify, to jettison claims, to tone down what you're saying, to be more precise. And lastly, and I'm interested to hear what Lisa has to say, I think there's this other component thinking about civility from a public-facing perspective. And this is hard for lawyers because when you are zealously advocating a client in the courtroom, that might feel different when you are in front of a microphone or on CNN making these statements and what kinds of statements you're making. We think that there's this code of conduct for attorneys that really is in the courtroom, but there's a sense in which it extends beyond the courtroom to the representations you are making with respect to this specific legal claim. So being careful and thoughtful in how you articulate those things as well. So it's definitely a challenge. I think it's a challenge when you have such pitched fights about high button or high salience, hot button topics of election litigation, but there's also a component that it really can look like any other form of litigation in terms of the civility and the representations you're making with respect to the facts of the case. Lisa.
So you asked about civility, and I think civility can be very helpful in terms of just sort of setting the stage for accomplishing things. But at the end of the day, where I think the stakes really are is less when it comes to people being civil to each other, which again, right, I like that, but more the extent to which civility tends to facilitate the rule of law. And once we start talking about the rule of law, then the stakes become extraordinarily high. And I want, when I say rule of law, I know that can sound like I'm saying something like law and order, but that's not what I'm saying. One way I think of understanding what the rule of law is to think about what it looks like if you don't have the rule of law. If you don't have the rule of law, that means you don't have publicly announced rules that are governing what happens to people, right? What the government is doing, for example. And those laws are not only sort of on the margin being enforced and applied in arbitrary ways, they're being applied in arbitrary ways just openly all the time. And that sort of regime is not one that I at least have lived through in my life. We've seen sort of real breakdowns in the rule of law through history. We've seen them in other countries. And what fills that vacuum tends to be really, really terrible. So if what we're sort of thinking about here is, how do we promote the rule of law in the context of these sort of difficult disputes over elections? What I would say, I guess, is there's sort of more granular things we can do if we're sort of thinking about these issues. And then there's bigger things that maybe are more general things. So if I could sort of talk about both. First, what kind of on a more specific level, like what can happen to help promote civility and therefore rule of law when it comes to these election-related disputes? Deciding questions early, wherever you can, before it's clear that a certain resolution of a given question, right? Okay, really quickly. So before Derek was talking about how undated ballots maybe should be thrown out in Pennsylvania. Rick was saying, no, that's not the right way of thinking about these rules. Those undated ballots should not be thrown out. You may have found that more persuasive. You may have found that more persuasive. Now imagine if Rick's right, Donald Trump becomes president in 2025. And if Derek's right, then Kamala Harris becomes president in 2025. Now who's more persuasive to you? And I don't know where you're all standing, but flip it, right? It starts to feel a lot different. And it's really hard for any of us to sort of adopt rule of law principles and really stand behind them when we really know we're not going to like the result. So first, decide the question whenever possible, decide it early. Second thing, try to achieve bipartisan consensus wherever possible. And that's one thing that Derek and I, in a sense, are trying to do in our statement. Let's find the principles that at least at some level of abstraction, everyone can get behind. And then the third thing is to remember that elections are complicated. They're logistically difficult. And there's practical import. So pull in election administrators. Let's hear what these folks have to say about these rules, because then maybe we'll understand that some remedy that somebody wants just isn't practically possible. And if that's going to be provided, then it's going to produce sort of all these other problems. All right, one last thing, and then I'll stop with this. So those are some technical things that maybe we could do, but what can all of us do on a sort of a higher level when it comes to sort of rule of law principles? I would say at least three things, and this is now, forgive me, I'd say this to my law students as well as anyone else who are listening. What can we do to help promote the rule of law? Be thoughtful about where you get your information and how and what you share. You all are becoming legally trained here. You're going to have a skill set where you can understand better than somebody who's not legally trained what's true, what's not true, where this information is coming from. Second, be thoughtful about, and you mentioned this before, be thoughtful, and Rick, Derek as well, be thoughtful about the sorts of arguments that you're really going to throw yourself behind. Is it worth it, right? Or should you put that energy somewhere else? And then third, I would just say, basically, as lawyers, we want to zealously advocate for our clients, but again, in the rule of law. And at some point, all of us, I think, should be ready to stand up for that broader set of principles, which is that there should be rule of law governing, regardless of whether it's sort of how it works out in a given case. So those are some things maybe to think about.
Great. All right, so we have time for a question or two from the audience, if anyone has any questions. It can also be of substance related to what's happening in the upcoming election, besides the topic of civility. Yeah.
I don't want to take time away from a student. I'm sitting back here, but
I think you're okay.
I'm curious. I'm conscious that I'm now asking you a question that's not like a legal question, right? But it's what's absolutely on my mind. I'm curious also about your take on sort of who cares about the question I'm about to ask, which is, what do we know empirically about what this litigation does to various audiences and stakeholders? And do people care? about the answer to those empirical questions, right? So like, I can make all kinds of assumptions about what this litigation does to things like voter turnout. On both sides, right? Does it make people feel like, oh, we need to win by a landslide, so I'm gonna vote because my vote's really gonna matter, even in a place where I think, my party's gonna win? Or does it make people feel like, oh, my vote's gonna end up in a warehouse somewhere, because there's so much also just like misinformation about, and there's just lots of coverage of the litigation. So what does it do to turnout? What does it do to perceptions of judges and lawyers? Do we know answers to these questions? And even if we did, would it persuade people? Because it's so interesting to think about, like, some of this is just baked into like what candidates can spend money on and what candidates can spend money on. So would they continue to do it, even if they thought it might not have the effect on the outcome that they're wanting?
So I recently tried to find sort of studies that are responsive to that question, and I wasn't able to find anything that sort of answered your question in a really robust way. I guess what I can say is that some people who have, for example, tried to empirically study the effect of voter ID laws, were surprised that the effects were actually not what they had anticipated, which is to say that the effects of having ID laws go one way or another did not actually seem to translate into a huge difference in votes, for example. So that may be one example where the sort of empirics behind it, there's a kind of mismatch between the rhetoric and the empirics. The other thing I would say, where you do see something that you can kind of measure more empirically, is the effect of a lot of this rhetoric, including rhetoric surrounding these so-called voting wars, on election administrators. And we're seeing, and this is a little not directly responsive, but we are seeing a lot of people who maybe would have worked in elections, resigning their positions, people not wanting to volunteer, et cetera. So that's 1 degree removed, but I would say that's something that we can track and that we are seeing, and that is very problematic.
From the voter side, it's hard to know how much litigation kind of gets into the voters' consciousness, right? They're aware that a complaint is filed maybe somewhere, but it's probably not in their state. Even if there's a resolution lawsuit, they may not see what that looks like at the end of the day. So yeah, this is a very fascinating question. It's very hard to measure. The one takeaway I think from Pennsylvania in 2020 is that the Pennsylvania Supreme Court there were worries about the mail service and the increase in absentee ballots and wondering if ballots would be sent in on time. So the Pennsylvania Supreme Court briefly issued an order saying we'll accept ballots that come in up to 3 days after election day, even though state law says they have to come in on election day. The Supreme Court the United States Supreme Court issued an order that those ballots would be segregated from the rest of the ballots. And it got into the public psyche. Oh, you need to make sure that it comes in by election day because there's a real risk it won't count after election day, even though there was a brief moment where that litigation suggested it could. And the suggestion from county election officials on the ground, again, not empirical, anecdotal, was there was an uptick in people mailing their ballots earlier than they would have otherwise anticipated because there was that kind of public relations campaign directly related to the litigation. So the universe of ballots that was at issue, around 10,000, which sounds like a lot, but like relatively speaking to what happens in other states, was much smaller than what you would see proportionally in other states that have an election day deadline for the receipt of those ballots. So again, there are ways in which we can think about that litigation does at the margins in certain ways affect how the public behaves in response to it. But a lot of it, I think, is just rage tweeting, complaints being filed with headlines from your media place of choice.
Well, it does seem like an opportune time to say that if you are voting by mail, you should get it in the mail as soon as possible, so you can still, even though the pandemic is over-ish, we still have problems with the US mail. Some of them are worse. We have time for one more question. Yes.
Hi, well, thank you for coming. My question, so I law student, so I've definitely seen restatements, hadn't really thought about the fact of like starting a new one. And so I was wondering, in the committee, where do you start? And in part, like, how do you get people, especially with the values of what are you trying to do? Like, when I think about creating rules, there's always trade-offs, right? So whether it is resource restrictions, whether or not if you're trying to have it be applicable to across the nation, rural versus urban, all of those various things. Also, you want to maximize the, accessibility to voting versus facilitation. So I'm just curious of whether or not the conversation started off with values, and especially given the fraught nature that you mentioned around the ability to vote, I would hope that that would be highly considered too. Especially because lawyers don't always reflect the most marginalized experiences and those who haven't been able to vote historically or today.
That's a great final question, so give each of our speakers a chance to respond.
Yeah, I'm sorry, very briefly, so one of the things that we're emphasizing this is a restatement of election litigation and election law. So there's a lot of law out there, constitutional law, the Voting Rights Act, the law of redistricting, things like that, substantive law. Our goal is to provide litigation related rules for election disputes. So in some respects, we were just talking about this morning, and it almost looks like election administration litigation. It's dealing with recounts and dealing with the timing of disputes and all things like that. And so we have in a way a narrower scope than just all of election law. At the same time, we have a very broad group of stakeholders of all types, as Rick mentioned earlier, a widely diverse array of perspectives that we're going to be getting on this project. But very early on, it's really Lisa and me deciding the scope of the project, and we're getting feedback, obviously, but we're looking at that. So the four major areas that we're thinking is sort of first some general provisions, thinking about like the right to vote entitles qualified voters an opportunity to cast a ballot and have that ballot counted. When do we construe rules strictly? When do we construe them a little bit more generously? Thinking about all of those things. Again, recognize there's trade-offs for everything, and how do we assess those things on a broad basis? Second, thinking about unique issues in the federal courts, issues about abstention, about certifying issues from the federal judiciary to the state courts, thinking about the relationship between federal courts and state courts and hot button election disputes. The third, kind of justiciability concerns, standing, mootness, rightness, and all the unique things with elections, because they're compressed timeline. Do we be a little bit more generous about when you can file early so that it's not moot later on, things like that. And then finally, some of the remedies, when do we issue injunctions? When do we issue a writ of mandamus? What do those things look like? So again, there are things that sound like civil procedure, they sound like federal courts, they sound like constitutional law, but we're coming at them all from sort of an election litigation perspective and trying to offer courts, again, those unique off the rack rules that they can apply in cases.
So I think one way of answering your question, I'm going to answer your question in sort of two ways. One way of answering your question is that the procedures surrounding the restatement process are supposed to ensure that there's sort of a diverse group of stakeholders who are able to provide input into the process and otherwise influence what's going on with the restatement. And to back it up to what our work is, right, when we are thinking about what this project should look like, in a sense, we're serving on behalf of ALI. So we need to respect the process, obviously, and sort of ensure that the way we are framing it and the values that we're adopting are those that we want to appropriately reflect ALI's values, which in turn is going to go to this sort of group of theoretically diverse group of sort of stakeholders who are going to sort of formally, either informally or formally have a role in the process. So one way of answering your question is there's various processes in place to help respond to that. Another way of answering your question is, yeah, you've really hit on a serious challenge here. Because that diverse group of stakeholders, they consist of, or diverse group of contributors and people who are advising us, who in turn, we hope are representing groups of stakeholders. Like the human beings who are going to be there are all very accomplished, influential people. So are these, are we talking to people who are themselves experiencing certain hardships or the like? We're doing that, but indirectly, right? So of course, this is going to be problematic in various ways. And to that end, I would say, so again, just to validate your sense here, it's a challenge, right? We're doing a technical project here that in a sense requires a certain amount of training to even know what we're doing and to be able to articulate sort of thoughts about it. So I guess what I would say sort of conclusion in that regard is that I think that reminds me and perhaps some of you of the privileges and responsibilities that go along with being law trained, being in a place and having a set of abilities where we're able to do this work and to generate these skills, because then we are in environments like this going to be the ones who then have to, as a practical matter, help to pull in these other voices and make sure that they're represented, at least in an indirect way.
Well, thank you. I feel like the legal profession and ALI is going to be in good hands as the project moves forward. And this today was a good example of what it means to have a discussion where we don't have to all agree on substance, but we can actually agree on goals, at least at a high enough level, and a commitment to rule of law values, the commitment to the right to vote that can serve as a basis for achieving common ground. So please join me in thanking our speakers, lead the management.